Hey everyone, Harry here to talk about the Supreme Court's unanimous mifepristone case, which ends a very long saga that never should have begun because the plaintiffs had, as I'll explain, had no business being in court. It will very possibly play in the media as some surprise, big, unanimous progressive result, but it really isn't that. It's just a very orthodox application of standing law that it always seemed to close observers of the court they were going to do, and now indeed they have done. This one was DOA and should have been DOA from the time that the court took the case. All right, but so as a reminder, right? So mifepristone now is a extremely important drug that is part of a two-drug cocktail, you could say, that is used in over half the abortions in this country. So if you are post Dobbs, very much a warrior for reducing abortions, you want to get at this drug. And there was a big challenge filed in Texas before a very activist judge there named Matthew Kaczmarek. Quick review of standing doctrine. It sounds very arcane, but it's just a way of saying the people who sue to overturn laws have to have skin in the game. Can't just say, I don't like that law, but have to be injured by it. And the plaintiffs here who sued were pro-life emergency room doctors. Fine. And what was their claim for how, well, and those are the plaintiffs. And the FDA, the defendants, what had the FDA done? They had initially approved mifepristone in 2000, and they had subsequently, as it had a very safe track record, relaxed the requirements for its use, including most recently relaxing the requirement of an in-office visit. So now it's something that can be used by getting it through the mail. That is huge in the wake of the post-Dobbs landscape, where some states might outlaw, but if women choose to use mifepristone and get it through the mail, it's very, very hard to enforce that against them, and that's as people know, that's what sort of sticks in the craw of a lot of anti-choice folks here. So the three different, I've told, three different actions by the FDA. It doesn't really matter so much now, though at certain points in the tortuous history of the case, that we singled out two of the changes, but not the original one. It actually went up and down the courts to the Fifth Circuit in a partial way, a very tangled procedural history, but I think it's all beside the point now. What matters is the challenge has been rejected, and here is why. The emergency room doctors needed to come up with some claim. Here is how the FDA's action, the thing that's being challenged, is harming them personally. So they have skin in the game. The first, they held two different theories here. The first is, it actually is understood that in the abortion area, doctors who can't be forced to perform abortions, and it's understood that as a injury to conscience, which is something that often is not allowed in the federal courts, but here it is. That's, if that harms your conscience, if you have conscientious objections to performing them, okay, fine. So, but what happened here? Well, the emergency room doc said that the new relaxed regulations might cause downstream conscious injuries to the individual doctors. How is that? Well, because it might be that the changes, if you don't see a doctor and the like, could cause, in very sort of speculative chain of inferences or assumptions kind of way, it could cause women to come to emergency rooms and potentially need abortions. And it's a very sort of far-fetched thing. It could happen, but the main reason the Supreme Court rejected it, and as I say, this struck me as DOA on standing grounds, is there's no showing at all by these plaintiffs that they would be forced to actually to do it. I mean, there are in especially pro-life states, you have doctors who don't perform abortions, and hospitals have procedures to swap people out if it actually comes to it. And federal law protects doctors from any repercussions for refusing to perform abortions. So there was just no showing that even if in some remote speculative chain of inferences way, the use of mifepristone by particular women leads to the need for an emergency room visit, and there leads to a need for a termination procedure, that the plaintiffs would have to do it in any way. So that's their first theory. You can see how the whole standing game plays out. Just as a sort of aside here, standing has become more and more important in the modern era because people launch all these challenges to laws that really don't harm them personally, but it's really ideological or political objections. But if you can frame a solid claim of injury, you can pursue those claims. It's not as if the ideological objections are impermissible in themselves. Well, they're just if they stand alone. So you need to come up with. So they found these plaintiffs who were, we'll sue. We're emergency room doctors, but then they stated their injury, and it just didn't amount to a hill of beans under federal standing law. So the first one is we might have to perform abortions if women use mifepristone, and then they eventually require termination. And then the other is a very far-fetched claim of economic injury. And, the thing about standing, it's got to be a concrete injury. It's got to be non-speculative, but it can be teensy. So a 19-cent lawsuit, they're standing there. The lawsuit wouldn't be very valuable, but of course people aren't bringing it really to recover the money. They're bringing it to enjoin the law or do whatever. So here's their very vaporous claim of economic harm. So the idea is, if they have to treat folks, it will divert resources and time from other patients to treat patients with the mifepristone complications. Also, it could increase their risks of liability, which translates into economic harm because of dangers with mifepristone. A really sort of, again, chain of speculations. But, I'm dealing with the mifepristone patient, maybe somebody would come in who I really make a lot of money from. It's so clearly kind of grasping. And as another aside, it's a friggin' scandal that the zealot pro-life district court judge Matthew Kaczmarek green-lighted this case. But anyway, so what did the court say about that? The causal link. So you have to be injured by the law. That means you've been injured, but also the law has caused it. And here they say, the causal link that, FDA relaxes the mifepristone restrictions in 2016 and 2021 is just too speculative, lacks support in the record. It's just, a really kind of supposition, and a weak one at that. And we've never, besides, done this sort of thing. If you could really challenge a public safety requirement because of this remote argument that it will somehow give an opportunity cost away from other economic gain, man, then, everybody's into the pool on any medical regulation of any kind. And that's the core of the case. Again, by Kavanaugh, there's a concurring opinion by Justice Thomas. I haven't read it, but it's making waves because apparently he uses the term abortionist for doctor here. So, which seems obviously very loaded. He really, I think he said one more aside, but Thomas, when he was confirmed, he said, they made me, that means the liberals, suffer for 43 years, and I'm going to make them suffer for 43 years. I mean, that kind of term, it just seems designed to be a poke in the eye with a stick, almost the sort of Trumpian idea of, owning the libs and riling them up. And, that's his sort of, heroism on the right. Okay, so after it's done, then a couple very sort of cleanup things. Is there associational standing? That is to say, there's an organization here, but basically you can have standing if your members have standing and not otherwise. And then finally, a ridiculous argument because it's been so often repudiated by the Supreme Court, but it's a good thing. You learn it in law school, and it's true. There are cases that just seem, wow, pretty harsh because the law is tough, and you think if these plaintiffs don't have standing, who does? And if nobody does, what happens? And the court has said again and again, and it ends this opinion by saying, the assumption that if these plaintiffs lack standing to sue, no one would have standing is not a reason to find standing. So that's a sort of, little tip on standing to remember. The court can be, strict or hard-hearted, you might say, but it's not an answer to the lack of standing of a particular plaintiff to say then nobody would have it. Okay, there you go. The long saga ignited by a ridiculous opinion by an activist fifth district court judge that goes all over the place and concerns different actions by the FDA comes to an end because the plaintiffs lack standing, can't show that they've been injured, can't show that the changes that they object to by the FDA, making mifepristone easier to obtain and use by women, has actually injured them. So end of the road on that for now. Of course, that says nothing about what's around the corner if they can find a plaintiff that has standing, something, actually happens, like where you can really trace the, ease of restrictions, say not seeing a doctor, to injury perhaps by individual women. Then would the court, strike down what the FDA did? It would be really a strange and aggressive move because the two-drug regime here, mifepristone, the core one, has proven extremely effective and safe. So the argument that they were making on the merits, which is this wasn't safe, or at least the FDA didn't consider it carefully enough originally, even though we now know it's quite safe, that would be a passing strange reason to strike down the law. But that, might be in the future if the pro-life forces can come up with a plaintiff here who's actually injured and has standing, but they couldn't this time, and they are at the unanimous end of the road from the U.S. Supreme Court. Just, I'll repeat where I started. Don't buy the presentation or the notion that this is some big progressive move by unanimous Supreme Court, etc. This is a case where standing was preposterous, and the court was going to say so, and they did say so. That anything else would just be spin. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.